fire this holy at a High Court's judge's residence in Delhi, the alleged recovery of a huge amount of burnt cash, and subsequently that cash going missing as it is believed to have been removed from the site the next morning. Well, this massive scam has set the judicial circles in the country alight. Justice Yashwant Verma is calling it all a conspiracy, but it is arguably the biggest controversy to have hit the Indian judiciary. Valid questions are being asked whether the processes in place to appoint and remove judges are adequate or thorough. Should transferring such a judge to another court or not assign him any judicial work even count as any punishment? Also, does the Justice Yashwant Verma matter now give a big handle and opportunity to the Narendra Modi government to press for urgent reforms in the collegium system and revive the debate on its premier move, the National Judicial Appointments Commission or the NJAC? The NJAC was struck down by the Supreme Court after the Modi government's law was passed by the Parliament in 2014. Hello, this is Aman Sharma and welcome to this episode of Homework, where we discuss the details of this big controversy threadbare and dissect how opaque the system currently is to appoint a judge and how difficult and challenging the law is to remove a judge. First, what has exactly happened? It was around 11:30 p.m. on March 14th that fire services rushed to the 30 Tughlaq Crescent residence of Yashwant Verma on getting a call about a fire in a storeroom at his residence. The judge was out of station when this happened. A report on the fire and a video captured on the site speaks of 4 to 5 sacks of burnt cash at the scene and speaks of a statement of a security guard that the burnt material was removed from the site the next morning. Justice Verma questions the discovery of any such cash and denies that it belongs to his family. One of India's top legal voices, Harish Salve, has said that investigating agencies would be at your doorstep with the scenario of raids and arrests if huge cash is found in your house. But judges do not face any such danger. Any action against judges is thorough, a long, complicated inquiry process.
The fire brigade and the police went into the judge's home to rescue it from a fire and found large sums of cash. Now, if this is true, it's something which has happened in public. And I have 2 or 3 reasons for which I feel this collegium decision is deeply flawed.
So let's talk about the challenging task of removing a judge on grounds of proven misbehavior or incapacity. Well, the route is an in-house inquiry by a 3-judge committee that has been instituted by the Chief Justice of India, like in the Yashwant Verma matter. If the judge is indicted in this in-house inquiry, the CJI can ask the judge to resign. If the judge were to refuse, the CJI could then write to the government to initiate proceedings for his removal by Parliament under Article 124/4 of the Constitution. That would then require an impeachment motion in Parliament, a complex and lengthy procedure, which must be passed by 2/3 majority in both the Lok Sabha and the Rajya Sabha. The matter can also be initiated by the MPs if a motion is moved by not less than 100 members of the Lok Sabha or not less than 50 members of the Rajya Sabha. A 3-member inquiry committee follows, and if the inquiry report finds the judge guilty, the motion for removal has to be put to vote in both the houses of Parliament for impeachment, and as I said, can be passed only by 2/3 majority. This, of course, is very challenging. Since removal is only possible on grounds of proved misbehavior or incapacity, the inquiry needs to find some concrete evidence. A committee of judges must investigate allegations, which is time-consuming and requires meticulous proof. Also, achieving bipartisan support in the Parliament is rare, adding to the difficulties. Look at the case of Justice V. Ramaswamy, who was the first Supreme Court judge to face impeachment proceedings. Despite being found guilty by the inquiry panel, impeachment failed in the Lok Sabha due to the Congress party's abstentions. the CJI simply stopped allocating work to him until his retirement. In the case of Justice Soumitra Sen, who was the first judge to be voted for removal by the Rajya Sabha with an overwhelming majority, he resigned before the motion could be tabled in the Lok Sabha, avoiding hence full accountability. In the Justice C.V. Nagarjuna case in 2017, the impeachment motion initiated in Parliament failed because several MPs withdrew their signatures. In one of the most high-profile cases involving the sitting Chief Justice of India, Deepak Mishra, the Rajya Sabha chairman rejected the impeachment motion at the preliminary stage itself. This was the first time in Indian history that an impeachment motion was moved against a Chief Justice of India. In the case of Justice P.D. Dinakaran, the Chief Justice of Sikkim High Court, his resignation came on the first day of an inquiry panel sitting. Well, this case highlighted the loophole allowing judges to escape accountability through resignation. So then, given how complex it is to remove a judge from his position, should not our country have a foolproof system to ensure only honest and well-meaning people become judges? That brings us to the second issue: how a judge is appointed in India. It is through the collegium system for nearly the last 4 decades, in which 5 top judges of the Supreme Court recommend names for the judges for the higher judiciary across the country, as well as recommend their transfers. The government does its due diligence on such recommendations, seeking intelligence inputs, and can send them back to the collegium. But it has no option but to approve them if the said recommendation is reiterated by the Supreme Court collegium. For the record, former Law Minister Kiran Rijiju had said that the collegium system is alien to the Constitution of India.
Collegium system is alien to the Indian Constitution. You tell me under which provision the collegium system has been prescribed. But because the Supreme Court, in its own wisdom, through a court ruling or through a case judgment known as first judge's case, created a collegium. Now that collegium, whether the Supreme Court collegium or High Court collegiums, they recommend the name. And government has to do due diligence.
In fact, do you know what was the first major step of Narendra Modi when he became the Prime Minister of India? It was to bring in a new law to replace the collegium system, and they make the process more transparent and maybe more fair. It was the National Judicial Appointments Bill introduced by the Narendra Modi government in 2014 and was passed by an overwhelming majority in Parliament and signed into law by the President of India.
National Judicial Appointment Commission Bill 2014 be kindly considered and passed.
Motion moved that the bill be passed.
But in 2015, in an unprecedented move, the Supreme Court junked the NGSE law to restore the collegium. The NGSE law, as passed by Parliament, had said a committee of 6 members would recommend names as judges. This would include the Chief Justice of India, the 2 most senior judges of the Supreme Court, the Union Law Minister, and 2 eminent persons. These eminent persons would be nominated by another committee consisting of the Chief Justice, the Prime Minister, and the Leader of the Opposition. The key provision in the NGSE was that if 2 of the members of the 6-member committee vetoed a name, the said person would not be recommended for appointment as a judge in the higher judiciary. This provision was a sticking point. This 6-member committee structure was entirely different from the existing SC collegium, which only has 5 Supreme Court judges and no other inclusion from outside. In fact, even before the NJSC, several high-level commissions had suggested that an independent body be set up to appoint judges to the higher judiciary. The Supreme Court struck down the NJSC, saying the executive involvement in the appointment of judges impinges upon the independence of the judiciary. SC said this violates the principle of the separation of powers between the executive and the judiciary, which is a basic feature of the Constitution. Vice President and Rajya Sabha Chairman Jagdeep Dhankar has now said that the NGSC would have addressed the issue of judicial accountability, but the SC had struck it down. Some in the government say that the SC was perhaps worried that given the 2-member veto power in the NGSC committee, the government would have been able to shoot down recommendations of the names of judges and push its own people. There were lots of doubts over the feature of 2 eminent people to be selected on the committee, with judicial activists saying these could be close to the government. But the government side says such assumptions were unfounded, as even the eminent persons were to be selected by a 3-member committee that consisted of the Chief Justice of India and the leader of the opposition. But still, the Supreme Court chose to consign the NJSC to the dustbin of history. The government still maintains its case that the selection of judges must be a broad-based process like in major countries of the world. Like in the UK, SC judges are appointed by a 5-person selection commission. In Canada, such appointments are made by the governor and council and a selection panel comprising 5 MPs. In the USA, the appointments are made by the president and confirmed by the Senate. While in Germany, half the members of the Federal Constitutional Court are elected by the executive and half by the legislature. Will the Yashwant Verma matter make the government and the Supreme Court together rethink the aspect of higher judiciary appointments? Well, it is high time that something is done. We will be back next week with another episode of Homework. Thanks so much for watching.